Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons have a business before this court will go on there and give their opinion. They shall be heard.
Morning, everyone. Please be seated. First case for consideration this morning is the People versus Felix Esquilin. I'm mispronouncing it. Apologize.
My guess would be Escalin, but I'm also guessing you're.
It's fine. I'll take it. Good morning.
Good morning.
Please proceed.
Jane Yoon from the Monroe County Public Defender's Office for Mr. Escalin. Mr. Escalin established at the hearing before the county court that he was entitled to DVSJ resentencing relief. And that is because he established by a preponderance of the evidence each of the three prongs, which I would like to go through.
Let me ask you a question first.
Sure.
We're gonna go.
Oh, you go.
Please go.
No,
Please.
go. Go ahead.
Okay, sure. I don't want to interrupt. I stepped on you. I apologize.
I take all questions, Your Honor.
All right. Considering item number 3, you know, whether the sentence is harsh. Didn't this court 4 years ago determine that the sentence at that time was not harsh and excessive?
Well, that was under the regular sentencing scheme, right? We're saying that he's entitled to DVSJ relief, and I think the court needs to take another look at it.
Wasn't he subject to potentially 25 years at that point in time with respect to the charge, and he received 10, and there was probably mitigating factors that the court considered at that particular time?
I think it might have been a different panel, first of all, Your Honors, but
Some.
so it's not just about, it's not,
some.
I understand that, but it's not just about whether or not he received the maximum or something less than the maximum. I think at the time, the court didn't know these factors, I don't believe. I think there may have been some hint of it, but not to the extent that was developed at this hearing. So I think the court needs to now reevaluate, knowing Mr. Escalin's history and what went on between him and the victim in this case, and to get a better understanding and to reconsider those factors, also given his age and given his lack of a criminal history. He was eligible for 5. So it's not that he could have been sentenced to 25, but that he was eligible for 5. He had no prior criminal record. He had I think a JD adjudication, which was about 5 years earlier. It appears that he successfully completed probation during that time. I didn't see any violations of probation with respect to that. So I think this court now has more information than it did when it first considered his original issue and request for reduction for harsh and excessive. So I think when you take all of that into consideration and you review it, having that information, I think allows this court to reassess that information and reassess whether the sentence was.
Now I'm going to jump in on the first criteria. At the time of the instant offense, the defendant was a victim of domestic violence, subjected to a substantial physical, sexual, or psychological abuse inflicted by a member of the same family or household. At the time of the instant offense.
That's correct.
This is years after he wasn't even seeing his uncle, correct? This is nowhere near at the time when he was living there and was subjected to it.
Well, I would disagree, Your Honor. I would say that as trial counsel argued in her closing arguments to the hearing court, the abuse never stopped. I mean, the uncle was deprived of the opportunity because Mr. Escalin absented himself in situations where, you know, he might encounter his uncle. That's, I think, actually just evidence of the constant abuse that he's suffering, because
He did when he was younger, yes, but there's years that go by when he was not subjected.
Well, that's because he absent,
I
right?
realize, but
So,
still, the language here is at the time of the incident.
well, I know that the courts have differed as to what at the time of the incident is. We would argue that he was still suffering abuse at the time of the incident, because the minute he encountered his uncle took advantage of that opportunity. The uncle had been deprived of the opportunity simply because Mr. Escalin made sure he wasn't around in the presence of his uncle. But the fact that the uncle, the minute he saw him, starts telling him to get out of the house and then punches him in the head, I think is evidence that the abuse never stopped. He was simply just deprived of the opportunity to do so.
But isn't your argument really that he's triggered when he sees the uncle more so than any abuse happened?
I think it was both, Your Honor. I believe in reviewing the closing arguments that were submitted by counsel, there was the argument that the abuse was ongoing and also triggered, so I think This factor really goes to prongs 1 and 2.
Is triggered enough?
Well, I think it would go to the second prong in terms of whether or not it was a significant contributing factor, right? Because it doesn't have to be the sole factor for why the conduct occurred. It's simply a significant contributing factor. But again, I would say the abuse was ongoing, and so that at the time of the offense, it wasn't anything that had ended. It maybe wasn't evident because Mr. Escalon made sure that he would remove himself from situations, which meant that he was separating himself from family. He was not attending family gatherings because he was so afraid to be by this man who had been abusing him since he was 8 years old. And I think another, prime evidence of the fact that the uncle would certainly take the opportunity anytime he had it was the incident that his friend testified about at the hearing when they're driving in a car.
So can we focus on the contemporaneous, so you point to a punch in the head, right?
Mhm.
Is that enough on its own?
Well, it's the cumulative effect of everything, right? Because it's not taken in a vacuum. The history between the two of them was such that the minute the uncle saw Mr. Escalon, he just starts saying, "Get out of here! You're not welcome here," and then punches him in the head. And that's an ongoing. It's just a culmination of the years of abuse that started.
So rather than leaving the scene, the situation and taking himself out of it, he went to his vehicle, went to a car, he got a weapon and came back and shot him, right?
Again, if this abuse had been going on since he was 8 years old, he did not expect to see his uncle in the kitchen when his grandmother, welcomed him to her house because she saw him outside and said, "Sure, go get yourself something to eat." So I'm sure that was not something he expected when he walked in. He was just looking forward to, a nice moment with his grandmother, which was greatly reduced because he was constantly absenting himself from family gatherings. And who doesn't want a home-cooked meal from their grandmother?
And counsel, the statute didn't mandate that the abuse be temporally proximate to the crime, does it?
I'm sorry?
The statute doesn't mandate, it's not required that the abuse be temporally proximate to the offense.
That's correct, Your Honor. And again, our position is the abuse never stopped. So it's ongoing, and it's still ongoing at the moment he walks in. So it's not the punch in and of itself that's the abuse. That's just part of the continuing abuse that he has suffered for 11 years. And again, he's also just 19 at the time. So I think that's something.
What about the encouraging alcohol and drug use? Is that?
From the uncle?
Yes, from the uncle.
I would say anything that happened from when Mr. Escalon was a child is constituted abuse, right? He was held gunpoint saying you have to consume alcohol, or, what are you, kind of like a wuss because you're not doing this? But also like the incident that his friend testified to at the hearing. The uncle could have driven away, but no, the minute he sees Mr. Escalon, he jumps on that opportunity to drive by the car where Mr. Escalon is a passenger with his friend, simply in a vehicle, to say, "I'm going to pop you." I mean, that just shows that the uncle, at every moment he had, every opportunity he had when he had contact with Mr. Escalon, was to subject him to the pejorative bullying behavior that he had been subjecting him to since he was 8 years old. So we would argue that Mr. Escalon did establish by a preponderance of the evidence that he was entitled to resentencing under the DVSJ. Thank you.
Thank you. Mr. Ash?
Good morning, Your Honors. Ryan Ash for the people. It appears that this court is very familiar with the facts, and I think that is a good thing because this court has authority to review this issue de novo. So if the court has any specific questions, I'd be glad to answer them, but otherwise I'll go through the factors. I think first, to answer Justice Ogden, your question, I would read the statute as having a requirement that there be a temporal nexus. I know the temporal nexus phrase is something that has come out in the case law and the common law, but the statute does lay out a requirement that the abuse be substantial and ongoing at the time of the offense. And I think that the case law is using the phrase temporal nexus to kind of approach that at the time of the offense in a different way and explain what they think that the legislature meant. And I think that's a reasonable reading of the statute that this court should continue to adopt. And Justice Greenwood, you had pointed out whether or not the punch at the house was enough on its own to rise to the level of abuse that would be protected under the statute, or protect is not the right word. I think that the answer to that is it would not. And my argument would kind of be maybe best by thinking about different time periods. In the first time period during his childhood for the several years, I think he was going through emotional manipulation from his uncle. There's nothing at the hearing or in the papers here that suggests that this is a credibility determination. I think that was certainly happening. However, I do think there was a break in, to use a different legal term, break in causation, but really a break in the temporal nexus between that abuse and this incident.
Wasn't there, most of the testimony, then, a major bulk of it was during the time that he was younger and lived in the
Right.
same household?
Right.
Is that right?
And I think, I mean, from a trial strategy perspective, that could be because that's where their strongest argument lies. And
But then there was a 10-year lapse between the two.
I think there's a 2-year lapse.
Yeah, 2 years.
And I think, right, and counsel's argument that defendant removed himself from the situation, I don't think that necessarily is in their favor, because that's the right thing to do. And the defendant here, I think, caused a break in that temporal nexus. And then when we get to the offense here, yeah, I mean, a few minutes, a few seconds ongoing, the violence and the threats that are happening at the grandmother's house that day, I think that's their best argument is, look, this is ongoing. There's abuse happening that day. But my argument would be that abuse isn't the substantial and an ongoing abuse that's required to be a kind of a through line from the main course of abuse to the actual offense here. And I think Your Honor's point about having a gun in the car, there's no explanation for why he had that. And I don't think there's any sort of inference that he had that because he's protecting himself from the victim in this case. And regarding harsh and excessive, this was a negotiated sentence. And as Your Honor's pointed out, there were more serious charges here. And I think that 10 years ultimately is a fair resolution, considering the fact that there were more serious charges on the indictment that I think the people could have proven at trial. Thank you, Judge.
Next case is 943 People versus Eric Kauka. 2 for 2.
Morning, Your Honors. May it please the court, Barry Connor on behalf of the appellant Eric Kauka. This conviction cannot stand because the prosecution never made a valid statement of readiness until after the expiration of speedy trial time, and they failed to turn over crucial impeachment material. The prosecution did not make a valid statement of readiness in order to toll the speedy trial clock until after speedy trial time had already expired. Discovery compliance and a valid certificate of compliance are prerequisites to a valid statement of readiness under People versus Bay. In this case, the felony complaint was filed on November 29th of 2020.
Well, did defense counsel fail to make a 30-30 motion?
That's correct, Your Honor. Defense counsel did not move for dismissal under CPL 3030. We asked this court to review the issue in light of defense counsel's ineffectiveness, in light of the clear-cut nature of the speedy trial issue.
There was never really a calculation of the time, though, was there, below by the court? Because then there was never a motion.
Correct. In this case, the issue is clear-cut based on the record. The speedy trial clock commenced on November 29th of 2020 with the filing of the felony complaint. But the only their certificate of compliance filed in this case was not filed until February 3rd of 2020. So the speedy trial clock
it is a lot of time, but there's likely some excludable time too, wasn't there? I mean, I think the omnibus motion was made in February of 2021, and the court's decision didn't come until October. So there is some time, and there were apparently some other adjournment requests, but that was never made as far as by the court, because there was never a motion before the court to consider this 30-30 time.
Correct. In this case, the clock was never tolled. So during that extensive delay, the people had every opportunity to file a certificate of compliance if they were ready for trial and make a valid statement of readiness in order to toll the speedy trial clock. But that did not happen. They did not file their certificate of compliance until days before trial. That goes against the purpose of just the discovery statutes, which is to eliminate trial by ambush.
Do we have enough here, though? Isn't this more appropriate for a 440 motion?
Your Honor, it is my position that given the very late filing of the certificate of compliance and the holding in People versus Bay, this goes again to the automatic discovery violations, which I can touch on a bit more. But I believe that the record is clear that the certificate of compliance, the only certificate of compliance, which the validity of the readiness statement was dependent on, was not filed until.
But aren't you required to show a non-strategic reason? And that's not really here for the delay.
In this case, case law such as People versus Madison, People versus Sweet have held that no strategy can explain defense counsel's failure to bring a claim that could have led to dismissal of charges with prejudice. In this case, defense counsel was aware that there was a very late disclosure of automatic discovery, which again, that also goes to the people's readiness. The people failed to conduct due diligence in order to turn over crucial impeachment material of their key witness. These convictions were not revealed until the third day of trial during voir dire, just before this crucial witness testified. The people conceded that this was discoverable material, that it was disclosed belatedly, and their explanation was that they relied on the county clerk in telling them that there was no further criminal history on this witness. This court has rejected that argument that the people did not practice due diligence in People versus Mitchell when they relied on the word of the county court and did not run their own repository check on their star witness. In this case, again, between the late filing of the certificate of compliance, well after the expiration of speedy trial time, as well as the late disclosure of automatic discovery, well after the expiration of speedy trial time, dismissal is mandatory. And again, defense counsel was ineffective for failing to make the speedy trial argument in this case.
Anything else?
If there are no further questions, I'll rest on my brief.
Thank you very much.
Thank you.
Porter?
Morning, Your Honors. Kaylin Porter on behalf of the people. Just to address some of the points that were mentioned today. So the 30.
Let me ask you something, right? Yep. Something that Justice Greenwood brought up as well. Isn't this more appropriate for a 440 motion? Is there enough in this record to even be making these?
I would not agree that a 30-30 motion or 30-30 issue should ever appear in a 440 motion. In order for that to happen, because anytime a defendant raises a 30-30 contention.
Wouldn't it be something more along lines? I'm sorry. Continue to answer.
So a 440 motion should be denied where it's an issue of record or could have appeared in the record. So I don't think this would be appropriate to decide a 30-30 issue in a 440 motion. In no small part because a defendant's burden is very easy to meet on a 30-30 motion. They just have to allege that it's beyond the 6 months, and then the burden shifts to the people. If that contention were to be made in a 440 motion, for example, then the people would in effect have the burden of disproving those claims by establishing excludable time. And because there's no time limit also on a 440 motion, that could be happening potentially years after the fact that the people are trying to compile this record of sometimes off-record requests for adjournment, things that really just don't appear in the record. So that really would effectively shift the onus to the people to disprove a 440 motion rather than a defendant proving a 440 motion.
I think it'd be more appropriate for the ineffective assistance of counsel because they failed to make this 30-30 motion.
Well, I think that is enough. I would say that enough is on the record because the first would reject the call to issue a decision on 30-30 in the interest of justice. But we do have enough in the record in order to see that the defense attorney had a reason to not bring it, because just even a cursory review of the record, you see that there's plenty of excludable time. Just looking at the record, there appear to be only 2 weeks that would be chargeable to the people throughout the entirety of the proceeding.
So, Counselor, is it your position that we should count the excludable time on this record? That's an exercise that we should undertake?
Not in terms of a 30-30 calculation, but just if looking at a reason why the defense attorney wouldn't bring this motion. Just a
right, we have to do, right, but that's the contention here is that there's no excuse for not bringing the 30-30 motion, given the fact that the people acted so late in the game. that there's no justification for not making it. So that's what we're looking at. And you're saying that we can, on this record, analyze whether or not there was a strategic reason or defensible reason for not making the 30-30 motion.
There's only no reason to not bring a 30-30 motion if it would have been dispositive, if it's meritorious.
Right.
So when this court is then looking at would this have been meritorious and considering whether counsel made a legitimate decision not to bring a 30-30 motion, you can
So
consider.
what if we were to look at the record and it's not clear to us? Well, we can't make that determination if it would have been successful or not. What does that mean then for the ineffective assistance of counsel claim?
Enough would still have to be established by the defendant because the defendant still bears the burden on an ineffective assistance of counsel claim. So I would say then that the burden would be on the defendant in order to establish not only was the statement of readiness outside of the 6 months, but there's also no way to view this record and see that there's any excludable time that would be chargeable and show that that motion would have been successful, that this would have been dispositive of the charges that the court had in front of it. So, but here there's only an allegation that it was beyond the 6 months. But if the court looks to the record, there is excludable time for virtually the entire proceeding. So if almost every adjournment request was at the behest of the defense attorney, that there were multiple motions filed, there were requests for adjournment that were made on record. There was even a note of an off-record adjournment request. But those types of requests would constitute the excludable time. So there is enough in this record to say that this would not have been a successful motion, even if brought. So it cannot then on its face be an issue that's so clear-cut and dispositive that the attorney was ineffective for failing to bring it, because just looking at the record, we have enough information there. But again, the 30-30 issue should not be decided in the interest of justice. That would have to be something that's preserved. The people would need an opportunity to respond on the record and compile that record, which could include off-record adjournment requests. That would be particularly important where there's any basis in the 30-30 motion, if it relies in any part on a 245 motion that's also brought at the same time challenging the people's diligence. So really that's something that needs to be established on the record. It should not be part of a 440 analysis. It should be something that's done in the first instance, because there's quite a few records that people would need to compile in that instance. Unless the court has any additional questions on any of the points, I will rest on my papers. Okay.
Thank you. Case 944, the people, in the matter of Alejandro GP. Gentlemen, good morning. Can you hear us?
Yes, Your Honor.
Yes, Your Honor.
Mr. Salcido, want to proceed?
Thank you and good morning, and may it please the court. My name is Stephen Salcedo. I represent the appellant mother in this case that arises from a neglect adjudication. As a very brief reminder, in this case, the mother was at work, and while she was at work, the boyfriend was at home at their apartment with one of the children and caused a bruise on that child. I'd like to touch upon the three substantive points in this case. Before I do, I just want to make clear that my client is challenging only the neglect finding in this case. She consented to the father's custody petition, and so the children live with the father has custody, and no matter what this court decides in this appeal, that won't change. So this is not about disposition, only neglect. Moving to the 3 points. The first point I'd like to touch on is this trip to Florida that my client took while the proceedings were ongoing. And the important thing to keep in mind here is that the neglect analysis has two prongs. And I'll oversimplify a bit, but in essence, the first prong is, did the parent do something bad? Did the parent do something wrong? We can call that a negligence prong. And the second prong is, did this bad thing the parent did cause serious harm to the child or an imminent risk of serious harm? Certainly, the family court was not happy that my client took this trip to Florida. It appeared to violate the court order. My friends on the other side emphasized that this was not the right thing to do by my client, and we're not disputing any of that. My client acknowledged at the fact-finding hearing that it was a mistake. But the point we're pressing in this appeal is the harm prong. Did her trip to Florida by car with these children, her children, cause them serious harm or put them at imminent risk of serious harm? And the answer is no, that the record doesn't support that. What actually
Counsel, weren't the children present when the mother was arrested for violating the court order? And doesn't that emotionally hurt the children? Isn't that emotionally significant harm to the children to see their mom put in custody?
I understand, and it could theoretically cause emotional harm, and that's DSS's argument. There's no argument about physical harm here. It's the emotional harm of seeing the mother arrested. And the Court of Appeals in the Nicholson case that I cite from 2004 is very clear that it has to be that possible harm is not enough. It has to be imminent harm. And in this case, the department could have done a lot more to try to prove actual emotional trauma to these kids from seeing their mother arrested. First of all, she did cooperate. That's what we know from the record. So this doesn't seem to have been some sort of like a fight with police or anything like that. It seems that she cooperated. But the department's only evidence of emotional harm to these kids from that incident was that they were scared, nervous, and kind of sad. It was only 7 words of evidence on that point, which is the department's burden to prove trauma. I also want to emphasize on that point, Justice Ogden, the Joshua J. case that I cite in my briefs, that's from the Second Department, 2013. There, the children did see their father arrested in their presence. And in fact, in that case, the agents broke into the apartment while the kids were there and then arrested the father. And in that case, the Second Department at least concluded that wasn't enough to prove emotional harm to those kids. Here, this is an easier case than Joshua J. No one broke in to any apartment or anything. It was just, yes, the kids saw an arrest, but is that...
And then weren't they also placed?
They were brought back to New York, yes, because this happened in Florida, of course. They were brought back to New York. Again, this could be, it's possible that that would be traumatic for some children, but the department needs to prove that it actually was, and the department didn't do that. And that's sort of my key point. And Justice Ogden, you did touch on the key issue, and that's our response to that, is the department needs to prove its case, and it didn't do that. If there are no further questions on that point, I want to move on to the issue of entrustment, that my client should not have entrusted the children to the boyfriend. The family court concluded that she was negligent by doing that because the boyfriend was a clearly inappropriate caretaker of the children. And I want to reiterate that the analysis here focuses on before this July 2023 incident, because the children did not live with the boyfriend or the mother after the incident, maybe a few days, but DSS's case is all about before the incident. Should the mother have known before the incident that he was not a good caretaker? And the most important factor here is, did the boyfriend actually do a good job caring for the children when he was doing that? He was a father figure to these kids for multiple years, 2 or 3 years. He had no history of child neglect. A social worker put on the stand by DSS testified that he had a close relationship with the children. The older child at least called him dad. I think very importantly, the father in this case, who probably doesn't like my side of the case very much, the mother or the boyfriend, he acknowledged at trial that the children never expressed a fear of the home to him. They never expressed a fear of the boyfriend in all those years that they lived together. And a social worker, one of the two, her name is Ms. Vasquez, she testified the same thing. She interviewed at least one of the children, and the child did not express a fear of the home. So the boyfriend had a long history of caring for these children, and apparently nothing went wrong up until this incident. And so
there was a police report concerning the boyfriend and the mother, wasn't there?
Yes, Your Honor, that was from January of 2022. This incident happened in July of 2023. And so I think my first point is the fact that there is this one police report about something that, even if it is true that it happened, because there's no conviction, no charges, even if it happened, it was not in the children's presence. I think that's important. Second of all, if we assume that's true, we've got that one incident from January of 2022, and then nothing happened. At least DSS did not suggest in this record that anything else happened for the next year and a half. And so I think if you're in the mother's shoes and you know that he's done a good job caring for the children, there was one incident, but nothing happened for more than a year after that, I don't think that her decision making to allow him to continue caring for the kids was so wrong that it rises to the level of child neglect. And I do want to also point out the Afton C case that I cited from the Court of Appeals.
Hold on.
Awesome.
Your
I
Honors.
didn't touch anything.
I think it's your fault.
I know it is. We lost you for a minute there.
You hear me now?
Yeah, we think we said you're winding up. No, I'm kidding.
Okay, I am getting close. The Afton C case is important here on this issue of the entrustment because yes, the boyfriend had some kind of a drug issue in the past. He was in treatment and hadn't failed a drug test for years, but there was some kind of a drug issue. He had some kind of mental health issues that was being treated. But in Afton C, the father who returned home with the children was a convicted rapist. He was convicted of rape involving minors. And the Court of Appeals concluded there that the mother was not negligent by allowing him to return home to be with the children. The boyfriend in this case is nowhere near the father in Afton C, nowhere near the severity of that situation in Afton C. And so I think here the on the entrustment issue that can't support a finding of neglect against my client, the mother. And the final point I'll make, and I'm wrapping up, Justice Montour, is about this argument that occurred when my client returned home to the apartment. She saw the bruise, and then there was an argument between her and the boyfriend. And the family court concluded that was an instance of neglect also by the mother. And the first thing I want to say is that, as I point out in the briefs, the Nicholson standard is what applies here. The domestic violence, if we can even call it that, had to be repeated and serious and in the children's presence. And there had to be some kind of evidence that they were traumatized by what happened here. And in fact,
Didn't the boy counsel say that the mother and her boyfriend were punching each other with their fists, and wasn't that again traumatic to the boy to see the man punching his mother
the child
with closed fist?
One of the social workers testified that that's what the child told her. As I point out in my brief, that was uncorroborated. The AFC's brief admits that it was uncorroborated. And so that hearsay cannot sustain a finding of neglect in this case. Further,
What about the testimony of the police officers, though, that said the children were scared and emotional enough?
Well, I was going to bring up the police officers actually next on Justice Ogden's point. On the one hand, we have hearsay from a 7-year-old that they were hitting one another. On the other hand, we have 2 police officers, obviously adults trained in the law and such, and they testified they didn't see any markings on any of the adults, that there was any signs of physical force used by either of the adults against the other one. And Justice Greenwood, to your point, these officers did see what happened. They have no skin in the game here. They're just doing their jobs. They
Well,
arrived.
you're saying they didn't see any marks of it. Didn't they testify the children were scared and emotional as a result of what they observed?
They did, Your Honor, and I don't think, similar to a point I made earlier, that being scared or emotional is enough evidence by itself to show this trauma. Go ahead.
No, I'm listening.
Sure. These officers, again, no skin in the game. They are just doing their jobs. They saw the end of the argument. They spoke to both adults. They saw everything that happened there when they arrived, and they did not make a child neglect report. They had been trained to identify and report child neglect. They're mandatory reporters under the law. They testified that they had made reports in the past, and they decided not to do so here. No criminal charges, no child neglect report. And one of them expressly acknowledged at trial that this incident did not rise to the level of child neglect. So yes, we have the 7-year-old hearsay. By the way, the 7-year-old also said that his injuries occurred during that argument. And I don't think there's any dispute now after trial that that's not true, that the injuries occurred when the child was leaning out the window before the mother even arrived home. And so we already have the child being wrong about a very important detail. No offense to the child. We all love the child, of course, but he was a 7-year-old at the time. And we have these police officers who were there, said they didn't see any evidence of physical harm. Yes, they did see some crying. The children, by the way, wrapped around the mother. The question isn't child neglect in a vacuum. It's just, did the mother engage in child neglect here? And the children were wrapped around her. She's the one who was crying. She's the one who called the police. And that's why I point to the Nicholson standard, because simply being a victim or being present during domestic violence doesn't make that person responsible for child neglect.
Very good. Anything else? Anything else?
No, that's all I have. Thank you very much.
Thank you. Mr. Fox, good morning.
Good morning. May it please the court. Russell Fox, Legal Aid Bureau of Buffalo, attorneys for these 2 children. Just to address the points that Justice Ogden made, we have a domestic violence incident which requires the police to come. The police, in their testimony, described the children as hysterical. We have the later apprehension down in Florida after the appellant's flight to Florida, where one of the children is described as being scared. And we believe that all this adds up, if not to outright emotional impairment, then to the risk of emotional impairment. There's a lot else here on the record. There were a lot of contradictions and inconsistencies, which led the court to make the finding that the testimony of the appellant and the respondent were not credible. But Your Honor, we think there's a whole, Your Honors, there's a whole constellation of factors here. But the two that Justice Ogden pointed out, I think, are dispositive. We've got emotional impairment with 2 police interventions with these children described as hysterical, respectively as hysterical and scared. Your Honor, the children are now in Puerto Rico with their father. If there are any questions about how they're doing or anything else, I'd be happy to address the court on those things, but otherwise we would rely on our brief.
How are they doing?
They're doing well, Your Honor. I was able to speak with them last week. I wasn't trial counsel on this, and I didn't do the appellate brief, but I wanted to talk to these children. The 9-year-old boy was very able to tell me how well he's doing with his father, how school's going. He sounded very happy. The 6-year-old girl is really not a conversant English speaker at this point. But I did have the assistance of somebody interpreting in my office. She's doing well. So we would just rest on the brief if there are no further questions.
Thank you, Mr. Fox.
You, Your Honors.
Next case, 946, in the matter of Matthew Olmsted.
Morning, Brian Jones, attorney for the child. I am relying on the brief, but here to provide an update on the child in accordance with Michael B. This is a situation where there's 5 sides to the story, none of them intersect. The parents do not get along. They have shown an ongoing inability to communicate. The child is diagnosed with a very significant anxiety and adjustment disorder, and that appears to be influencing the entire situation. The child is consistent in expressing the desire to be exclusively with the mother and has gone back and forth between not wanting any contact with dad and then recently saying, I want to be with mom and sometimes see dad when I want to. The prior AFC did substitute judgment. I am not going to go as far as to do so, but I do believe it would be in the child's best interest to be with the mother and to re-engage in therapy, both individually and with the father. Son and father had a good relationship until the new girlfriend came into the picture, and things happened really quickly. And my impression is that that's where a lot of the struggles have come from and is stemming from.
Child is with mother.
He is with mother,
But the court found parental alienation.
yes, there is some manipulation that's going on with this. There's power struggles between both parents, and it's kind of my way or no way, he said, she said. So there still is time where child is with dad.
Right.
And
But based on what's going on now and based on, the court's finding, what would you like us to change in this order?
I would like the therapy to be mandated, that the child engage in therapy outside of school and some sort of, not reunification, but therapeutic engagement with child, father, and therapist to work through some of the struggles that have come about because of the girlfriend.
Was that addressed all below as far as the therapy? How was, what happened? Nothing happened?
It was not. There was therapy going on, and then one of the parents decided that therapy was not appropriate and did not believe it is something that should be going on and ended it. The school was a bit surprised that happened because they had seen the difference in success and acting out and struggles when therapy was
But
in place.
this order was April of 2024, correct?
Yes.
So wouldn't that type of change be more appropriate in a modification petition?
Yes. It like would. There has been so much back and forth that sending it back, I don't believe would benefit anyone.
Thank you very much.
Thank you.
Good day. Next matter is 947, Donna Fino versus Macy's Retail Holdings, Inc. Mr. Schwartz and Mr. Cosgrove, good morning. Can you hear us? Mr. Schwartz, you are muted, and Mr. Cosgrove, you are both muted.
Does that work now?
That works well.
Very good morning, sir. How are you?
I'm good. I'm good. Thank you so much. Why don't you proceed?
Thank you, sir. So Stuart Schwartz on behalf of Granville Elevator in this particular case. So this is a case in which the plaintiff claims that she was injured as a result of a misleveled elevator, brought claims against Macy's and my client, who is the elevator maintenance company. Summary judgments were heard, and the summary judgment was granted to defendant Macy's on the issue of liability vis-a-vis the plaintiff, but also given contractual indemnity as unconditionally as against my client. And the problem that we have, obviously, with that issue is the unconditional granting of the indemnification. The indemnity clause in this particular case is clearly violative of Section 53321 of the General Obligations Law because it contemplates total indemnity, even when the promisee is going to be negligent. And the language here specifically states.
Counselor, before you get into the analysis of the statute, though, you just told us the court below found Macy's not to be negligent in as much as it granted Macy's motion for summary judgment here. Isn't that a factor? Don't we have to consider that even before we look at the statute?
No, sir, because the reason is when the issue is when the contract is negotiated and entered into, is the language of the thing such that it is requiring a promise.
I guess let me be clear in my question. Does that statute that could otherwise void this provision, the indemnification provision, does it even matter? Does that statute even apply if Macy's is not negligent?
It does when you're negotiating the contract, yes, as far as its effectiveness, I believe it does.
But in terms of analyzing the effect of that indemnification provision on your client, doesn't it make a difference that the court found Macy's not negligent? That's my question to you.
Well, if the statute was not in effect and it was solely relying on the agreement itself, you're right, it would have no effect. But as far as the statute is concerned, the statute wants the agreements when they're entered into to be able to be a situation where this type of language is not allowed, is being void against public policy. So the question is really at the time it was entered into, not ultimately at the end of the day when the findings take place. So that's the first point that I would, in response to your question, Your Honor, is that the issue is when it was drafted, was it violative of the provisions of the statute? And it clearly was. The other factor here is, quite honestly, in addition to that, even if we go with that analysis, Judge, as to whether that makes a determination here, the court was incorrect in granting it because there is another condition precedent that's part of this particular indemnification clause, and that is that there's a finding of fault or some type of a failure on behalf of Granville, and that did not happen in this particular case. There's been no evidence or determination that whatever happened with the elevator was something that occurred as a result of or out of an act or omission on behalf of Granville. So if anything, even if the court were to find that the indemnity provision is valid and not violative of the general obligations law, the court's error was granting this unconditionally as opposed to making it a conditional determination pending a finding of liability or fault on behalf of my client.
Anything else?
No, sir. Thank you.
Thank you. Mr. Cosgrove.
Morning, Your Honor. May it please the court, James Cosgrove for defendant Macy's. It's our position that the lower court properly granted our motion, including the award of indemnification. And with respect to the particular indemnification provision, that certainly is not in violation of the general obligations law. As the court pointed out a moment ago, any negligence or perceived negligence on the part of Macy's was put to rest when the lower court granted the motion for summary judgment. And here, with regard to the particular provision of the indemnification provision, it clearly states that Gallagher shall indemnify, defend, and hold harmless from and against any and all claims, whether meritorious or not. And in this particular case, we've got claims in the plaintiff's bill of particulars against Macy's and against Gallagher that the elevator was not properly maintained and was not functioning properly. Those would be issues for Gallagher to undertake and to correct. And in this particular case, given the fact that there was no negligence on the part of Macy's, and given the fact that a claim was made against Macy's, whether meritorious or not, given the language in the indemnification provision, Macy's is entitled to indemnification from Gallagher Elevator. And unless there's any other questions, I'll rely on my brief.
Thank you very much, gentlemen.
Thank you, Your Honors.
Next matter is the Town of Fremont versus New York State Board on Electric Generation Siting. Miami, can you hear us?
Yes, I can, Your Honor.
Thank you.
Good morning, Your Honor. May it please the court. My name is Benjamin Wisniewski of Wisniewski Law, PLLC. I'm the attorney for petitioner, the Town of Fremont, in this original proceeding, which is brought pursuant to Section 170 of the New York State Public Service Law.
Mr. Wisniewski, may I ask you a question? Would this matter be moot now? Isn't the project done? All the turbines are up, roads are in, the lines are in, they're operating, turbines are turning.
Your Honor, it's I think a question I've anticipated, and I'll try to provide a response here. As the court is aware, respondent has filed pictures as a post-submission filing showing that the turbines in this project have now been constructed, and they have also asserted they'll be in commercial operation imminently. So the question obviously is, does this moot the claims that have been brought by the Town of Fremont in this petition? And it's our position that the completion of construction absolutely does not moot the Town of Fremont's claims. We think that if anything, it really proves them, and it proves the thrust of our argument. The thrust of the town's argument has always been that whether it was intentional or not, and that's something we can't know, the siting board has done everything in its power to expedite the construction of this project while either slow walking or simply ignoring the attempts by the Town of Fremont to move through the administrative process and challenge the certificate. The Town of Fremont has argued from the outset that the harm arising from the siting board's refusal to make a timely decision on its petition for rehearing would be that we'd come to a point where the project would be constructed and operational even before the court here could make a decision on this appeal.
Is there a statutory or case law that talks about what a timely decision is? And isn't the whole point of these boards to overrule local laws? Because otherwise it would normally go to a town planning board, for example, right? But it doesn't. It goes to...
Yes, Your Honor. So first, to address the first question about is there a statute addressing timeliness of petition for rehearing? So in this case, yes, you're absolutely right. This is a state process. The state process preempts or overrides the normal local zoning and planning process. So this is a very large industrial wind turbine project that was brought to the New York State Board on Electric Generation Study and the Environment to process the application. This is an old case. It's a large project that's been handled in basically 3 phases: an initial certificate, a first amendment to the certificate, and this specific action relates to the second and final amendment to the certificate. So as part of that, there was a process. The town participated, it submitted evidence, it opposed numerous aspects of the project. And ultimately, the siting board issued a second amending order, which modified the certificate. It was then incumbent upon the town of Fremont to bring a petition for rehearing to the siting board within 30 days. It did so. Then pursuant to section 170 of the Public Service Law, it's incumbent upon the siting board to issue a decision on that petition for rehearing within 90 days of receiving papers. That happened at the end of October of 2024 is when that deadline passed. Now, the question here is there any harm to the town of Fremont that's caused by the siting board failing to not only issue the decision by October, but waiting all the way until March or April of the following year? And there is harm because PSL 170, which provides this deadline, is a jurisdictional statute. It is the basis of this court's jurisdiction over this matter. And that jurisdiction is exclusive. We cannot bring this case anywhere else. So effectively, the town of Fremont was barred from appealing any further until it received the ruling on rehearing. And unfortunately, the siting board simply didn't issue it until shovels were already in the ground and this project was well under construction. Your Honor, concerning the issue of local law, that is another issue that we certainly raise in our papers. And that goes more to a specific issue of whether or not the siting board properly waived the town of Fremont's local laws as they apply to things like setbacks and turbine height limit. And just to be perfectly clear, the town of Fremont does not challenge the siting board's power to waive local laws. That issue has been decided by this court and other courts multiple times in the last few years. The question here is whether there was any evidence at all in support of the waivers that occurred. And we argue that when it comes to things like setbacks, there is no evidence because there was no evidence in the record about the manufacturer's recommended safety standard. And pursuant to the local law, the minimum setback was either going to be 1,500 feet or the minimum recommended safety
But
standard.
isn't that what they did, the 1,500 feet? Wasn't that?
They did, Your Honor, and this forms the basis of another cause of action we brought. The town of Fremont asserts that 1,500-foot ruling is arbitrary and capricious because in its own ruling, the siting board agreed with the town of Fremont that the correct setback pursuant to the statute was 3 times turbine height. The reason that shows as 1,500 feet within the statute is that there was also a 500-foot turbine height limit in the case. So that the town didn't anticipate a scenario where the 500-foot would be waived. Therefore, the minimum setback would have been 1,500 feet. And again, it's in the record, it's in the papers. The siting board agreed with this. They said, yes, we think it's reasonable that the town would assert the real minimum is 3 times turbine height. And furthermore, going even further back into the record, you'll see that that's the applicant's own position. They initially said that any turbines taller than 500 feet would be a problem because of the enhanced safety standards that they need to apply by their own internal safety standards, which again are far greater than the 1,500 feet that were ultimately applied by the siting board in this case. So again, Your Honor, to circle back to mootness, we do not think the issues are moot. Another reason we don't think the issues are moot is because it's not as if the town of Fremont was only requesting complete decommissioning of the project immediately. There are multiple different prayers for relief in this case. On the low end, we're seeking simple declaratory judgment that the siting board has an obligation to decide within 90 days. And if they fail to do so, then these claims ripen and towns like Fremont aren't forced to sit and wait before bringing an action. If the town had been able to bring an action sooner in this case, it's possible they could have done something like seek preliminary injunction at a time before shovels are in the ground and these turbines are under construction. There are other causes of action that ask for specific pieces of the certificate to be annulled and for this matter to be remanded back to the siting board for further development of the record. So in that sense, the court might issue an order saying that perhaps the setback should not have been waived because there's a lack of evidence in the record on what the manufacturer's safety standard is. You could annul the portion of the certificate which allows the exceedance of the manufacturer's safety standard. You could order a temporary cessation of the operation of only those turbines that exceed that standard or exceed whatever it is in the record. And then you could remand it to the siting board for development of the record. So this wouldn't require complete and immediate decommissioning or shutdown of the entire project. It's also important to note that we're really only dealing with phase 2 of a large project. So I believe phase 2 has 26 turbines, phase 1 has something like 32. So we're asking for really only a portion of the 26 turbines of phase 2 to be shut down, while this is remanded to the siting board to do the job it really should have done in the first instance. And there are multiple other prayers for relief, which are stated in the alternative, and we understand there's a lot there. We're trying to provide many options.
Anything else? I think we understand your argument.
Okay. Moving on to the issue of latches, which is another affirmative defense that has been waived here. That argument is really coming in two forms. First, respondents are arguing that the town should have brought this case sooner in general. And then they're also arguing that the town really had an obligation to bring a motion for preliminary injunction to preserve the status quo. I've already addressed why the town was barred by statute from bringing this sooner. So we were not dilatory in bringing this case because according to the plain meaning of Section 170 of the Public Service Law, we cannot bring a case until after the petition for rehearing is received. Once we received a rehearing, we did it within the statutory timeframe. When it comes to the question of whether or not we should have brought a motion for preliminary,
And I guess your argument is that basically Section 170 was violated, and since it was violated, where they didn't make their decision within 90 days and waited such a long period of time, you weren't able to bring this matter until all the administrative actions were relieved or resolved, right?
Yes, Your Honor. And when it comes to preliminary injunction, the problem is that the town considered this and intentionally decided not to bring an action for preliminary injunction because we didn't believe we'd be able to show irreparable harm. And this flows from the reality that within this case and in the record, there's evidence of this, citations to it. There exists a decommissioning agreement and a decommissioning letter of credit. They were enforced last November, long before this case was commenced. And even if, for example, the court were to make the most extreme ruling here and order immediate decommissioning of the entire project, phase 2 of the project, and if that were to be so financially burdensome that that the respondent had to declare bankruptcy, the town would still be able to take recourse to the $5 million decommissioning letter of credit, conduct the decommissioning itself in accordance with the agreement, and be reverted to the status quo pre-turbine. So we felt that proving irreparable harm, given the existence of these separate agreements, which have nothing to do with the certificate and are still fully enforceable, would make it futile and a waste of time, frankly, to bring a motion for preliminary injunction. Unless there are any further questions, I will rest on my papers.
There don't appear to be any. Thank you so much, Mr. Susi. Mr. Pavelka?
Good morning, Your Honors. May it please the court. Tim Pavelka on behalf of the siding board. First, I want to get to the issue of mootness. This case is now moot. The turbines are built as co-respondents counsel indicated by a letter a couple weeks ago. All the turbines are up. They provided pictures, and they indicated they expect to be operational within the coming weeks, by the end of the month, I believe. And so when evaluating the issue of mootness, the most important factor there is, in the context of a construction project, whether the challengers to that project sought to preserve the status quo at any stage that was available. And here it's undisputed that when petitioners initiated this proceeding, they did not also bring a motion for preliminary injunction at that time. And that's important.
Well, when you talk about mootness, I mean, these are turbines, right? I mean, it's not like we're dealing with a 10-story structure with 150 apartment units and things along those lines, which obviously would be very difficult to remove in that respect. I mean, these can be removed. I guess ultimately they would become not feasible and maybe have to be taken down at some point in time when your decommissioning agreement, sort of takes that into consideration. So, I mean, in theory, the wires could be brought up, the roads then covered over, and then basically come back to a pristine town of Fremont property there. So is it actually moot?
Yes, Your Honor, the project is built. It is complete.
I guess it could be taken down.
Well, one of the factors in assessing that possibility is whether that would create undue hardship to the developer here. And,
Well, if there was some inconsistencies taking place below, I mean, by the siting board, et cetera, and violations were made, things weren't properly taken care of, where this court could then say, do it over.
I think.
I know you don't want us to do that, but in theory, I guess I'm just.
Yeah, I suppose that raises a couple points. And well, whether it could be. Let's see. The question as to whether the board made any mistakes. I think the main mistake that the board would concede is that it did not issue its determination on rehearing within the 90 days directed by the statute. But that point by itself is only part of the.
So weren't there various orders given permitting you to continue this construction with an understanding that if something went wrong, you were gonna have to take them down?
Well, during the pendency of the rehearing, the company made some compliance filings about proceeding with some of the maybe kind of preparation style of construction activities. But it's undisputed here that the turbines didn't actually start going up until after this proceeding was initiated. And so as far as, whether there was, whether there was any harm flowing from the board's delay. That's.
I don't know that harm, but there's understanding that, hey, we're taking the risk here.
Well, during the pendency of the rehearing, that risk lay with the developer of the company.
Right. And that's basically.
That burden shifted once the decision on rehearing is issued.
Right. That was so many, beyond the 90 days requirement, but you took the risk, right?
Yes. So that risk lay with the developer.
The risk was that if something was wrong, we'd have to take them down.
That should the board have modified its determination anyway on rehearing, that would have required adjustments that the company took on that risk for proceeding in that interim period.
Okay. Why don't you proceed? I guess I've taken enough time on that petition.
Yes, Your Honor. Just to note on the timing limitation as well, I want to be clear on that the timing limitations of these statutes for agency action are generally mandatory directory, right? And here there's, that this time limitation is directory because there's no sort of consequence considered by the statute or any limitation on the board's discretion if it didn't act within that period of time. And so once you're dealing with a directory statute, in order to be entitled to any relief for that delay, there has to be a showing of substantial harm, which, as we pointed out, the timing of this case, the construction of the turbines hadn't started until after this proceeding was brought, and there was no harm flowing from the board's delay here on that. Moving to some of the substantive arguments with respect to turbine height and setbacks. Article 10 requires the board to ensure compliance with local laws, with, of course, the exception it can waive compliance if it's found that applying a specific local law would be unreasonably burdensome in a specific context. And so here the board waived a single local law, and that was the turbine height restriction. For the board, Barron provided evidence that in its amendment petition that these taller turbines would be both more efficient and generate more energy, and due to some of the other characteristics would actually result in fewer permanent environmental impacts. And that proof, was not contested by Fremont before the board, and so the board rationally accepted those reasons to waive the local law there. As it relates to setbacks, Barron did not seek a waiver, and the board did not grant a waiver of the local law. I believe opposing counsel mentioned that the citing board agreed with the town's interpretation that the minimum setback from non-participating residences was 3 times turbine height. Maybe it's referencing a portion of the board's order where the board maybe recognized that was.
Wasn't that the position of the petitioner that, I'm sorry, not the town, of Barron Winds, that, you know, when he originally made this application back in 2016, that it was 3 times?
I think Barron's counsel might speak better to that, but as I understand, that was more of guidelines about the proposal. But in any event, what the board was doing here was assessing an amendment petition. And so what it was required to do is determine whether this amendment petition complied with the requirements of Article 8 and the local laws. And here the local law says 1,500 feet. And that specific amount is maybe more relevant in context, given that they use kind of ratio setbacks from other things like public roads, rights of way, and et cetera.
Counsel, can I just ask you, by what authority does the siting board waive the local law?
The express power contained within Article 10.
Okay.
And that's, I believe opposing counsel said that they're not challenged the board's ability to do that. Similar regimes have been upheld with respect to citing public utilities and matters of statewide interest, like these kinds of energy projects. Lastly, just touch on the capacity issue. Just want to state that the board never changed the capacity approved under the original certificate. There was maybe some confusion about whether describing the specific phases. The board made clear in its rehearing order that it was not setting specific phase limits. It was just reaffirming that the applicant could not build above the originally approved 242 megawatts, and that never changed. Unless there are any further questions, we rest on our brief.
Mr. Pavelka, thank you so much.
Thank you.
Ms. Kami?
Very good, Your Honor. Good morning, Your Honors. May it please the court. Jessica Klami with the law firm of Young Summer on behalf of respondents Barron Winds and Barron Winds 2. I do regret that I'm unable to be there in person. Yesterday's snowstorm prevented me from traveling from Albany. And, I note that severe weather patterns underscore the broader statutory framework in which this case arises. Barron Winds project is integral to New York State's climate and energy mandates under the Climate Leadership and Community Protection Act. And the CLCPA requires that 70% of the state's electric sector be powered by renewable energy by 2030. Projects like Barron Winds are precisely the type of large-scale renewable facilities that the state relies on to meet those commitments to support a clean, reliable, and modernized grid. With that in mind, Barron Winds has constructed phase 2 of the project. The construction on phase 2, and I think a timeline is important, began in November of 2024. That was after the 90-day period for the rehearing to expire. And Barron Winds commenced that construction under a valid certificate with their amendment order. Your honors are correct that Barron understood that there was a rehearing pending and was willing to commence and begin construction with that rehearing pending. What Barron Winds, was not anticipating was a delay in that rehearing issue. But more importantly, is they were not anticipating, and the town's actions did not indicate that they would appeal any sort of rehearing decision. The town had an opportunity once that 90-day period expired. And in fact, in filings to the siting board, they indicated that if construction were to commence, they would be forced to seek a preliminary injunction. They never did. They continued to accept host community payments. They continued to comment on compliance filings that were filed by the applicant, and they never sought judicial intervention. The fact that they believe they may have lost, and that is not, pertinent to Alachi's claim. What's pertinent is whether or not they sought any preservation of their rights. And here they did not. Barron continued on with construction of over $100 million. The turbines are fully erected and will be going operational at the end of this month in accordance with their NYSERDA contract. They had to become operational by the end of 2025. So there's a lot of substantial harm to Barron Winds at this point if the project were to have to be reversed in any way. Hundreds of millions of dollars have been spent. This project has been, and this amendment for phase 2 has been in front of the siting board since September of 2022. That is 3 years, over 3 years. If the state has any chance of meeting any of its CLCPA goals, projects must proceed as quickly and as efficiently as possible, notwithstanding some procedural hiccups that may come along the line. So with respect to whether or not the town preserved their rights, it's our position that they did not, that Fremont had an opportunity, and if they believed that these timelines were mandatory, as they claim, they should have sought judicial intervention sooner. With respect to their claim that the 90-day timeline was mandatory, not directory, we would note that the language in PSL 170 allows for the applicant to waive that deadline. It allows the siting board to extend that deadline. So there's nothing in that deadline that would have indicated to the town that it was mandatory at the 90-day mark.
They didn't do that though. They didn't extend it or.
They did not by any formal order, no, Your Honor. But I think the case law is pretty clear that, for directory, not mandatory orders, there's no invalidation of, in this case, the amendment order.
That's your argument that it's directory.
Correct, Your Honor. With respect to, some of the claims we've raised about the town raising new issues or failing to preserve their issues, one of the big claims by the town is that the setbacks in this proceeding are somehow not correct. Either the local law required a greater setback, or that the original order required a greater setback. And on both of those issues, the town has presented no evidence in the underlying proceeding. They relied on legal briefs. They did not put any of their town board members up. They did not indicate any, underlying, they didn't submit meeting minutes, none of those things which could have supported a claim that the town meant for their setbacks to be something other than the local law said. The town has continued to say their intent with no evidence of their intent for greater setbacks than what's required by the local law. And PSL 166 requires that the town to have submitted evidence in support of an interpretation of their local law. And this court has held in similar proceedings that the siting board's interpretation of a local law is valid. The siting board does not have to follow a town's interpretation of their local laws. And here it's clear that the siting board looked at the local law, and its plain language was 1,500 feet from non-participating residences, and that's what it applied. And that's what the evidence underneath in the court at the hearing was consistent with. Lastly, the orders were not arbitrary or irrational. They were supported by extensive unrebutted evidence. Again, the issues in front of the court here have to do with setbacks and height, in addition to the procedural issues we've been discussing. And the town submitted no evidence that the height waiver was not, that the height limit was not unreasonable, and that the waiver should not be granted. And again, the town submitted no evidence on their quote unquote interpretation of their local law. There was more than enough evidence in the underlying, substantial evidence in the underlying record to support what the siting board did here, which was waive the 500-foot height limit and apply a 1,500-foot setback residence to non-participating residents. And the town has not shown that there was any lack of evidence in that respect. A disagreement with the evidence is not the same as not meeting the burden of substantial evidence. And finally, Your Honors, with the nameplate nameplate capacity, it's quite clear from both orders that the total across both projects was 242 megawatts, and that the siting board had no intention of limiting phase two as long as phase one and phase two collectively did not exceed that total megawatt threshold. In conclusion, Your Honor, the town's claims, are unsupported, are now moot, and the siting board orders were rational, grounded in unrebutted technical evidence, and fully consistent with Article 10. If there are no questions, I would rest on my papers.
Thank you so much. Have a good day.
Thank you.
Next matter is 949 Black Chief versus Prim and Herbst. Eminger, good morning.
Good morning. May it please the court, Rachel Eminger on behalf of the Herbst defendants, appellants. This is our request to reverse the order of the court below and dismiss the complaint against my clients, the Herbst defendants. In the court below, on our motion for summary judgment, we established that the Herbst vehicle was stolen from their private driveway and operated without their permission. Under these facts, there can be no liability against them. These facts were not disputed in the court below. Instead, the argument was that the Herbst defendants breached a duty to protect their property. That duty and claim does not exist. Therefore, no question of fact on that issue. The second argument below was that discovery was needed to determine the precise location of the keys inside the vehicle.
Is that right? Is that relevant at all?
That is not relevant whatsoever. That is only relevant if the statute applies. The statute does not apply. Therefore, under the facts below, our motion should have been granted. Candidly, I do think my colleagues are aware of this, which is why on appeal there were some new arguments presented, which were not presented below and are not preserved for this court. I just want to touch on them very briefly. The first one was permission, permissive use of the vehicle. At no point in the court below was that disputed whatsoever. And in fact, opposing counsel actually based their argument on the fact that there was no permission and that the vehicle was stolen. The case that's cited is the Countrywide case that they attempt to rely on, that my clients somehow did something. Countrywide states that any speculative assertions as to that are just not sufficient.
Right, isn't that basically what we're looking at from the perspective of the plaintiffs in this matter, that something must have been afoot?
Yes, without any basis in fact or reality.
The daughter's car next door, same thing, being stolen in the driveway still, but the keys were in there. Same night, same occurrence, same time, correct?
Correct. Vehicles are stolen. These vehicles are stolen.
And they both have keys in there, right?
Correct.
It appears as though the perpetrators
stole multiple vehicles.
They did steal multiple vehicles, no dispute on that, right?
That is correct, but that does not change the facts, the law, or what the appropriate outcome is of that case.
Aren't they basically inviting somehow that this is criminal activity be brought about?
So that was another argument that was brought up on appeal that was never even mentioned whatsoever below. And that was under the Epstein case, that we virtually invited the theft by simply parking our vehicle in the driveway. And aside from that not being preserved, the Epstein case doesn't actually carve out that exception. The Epstein case involved a theft from a dealership. And actually in that case, they felt that there may have been a higher standard because it was a dealership. Even with that, the second department affirmed by the Court of Appeals says—
I think they were saying that, well, not in this case, but maybe there's a case down the road where the facts would be, determinative that we should consider this, whether or not there was some sort of invitation here Right. I mean, in this instance, I think the plaintiffs would be arguing that, well, again, looking at the video, these perpetrators came look as though that they're aware of the fact that these vehicles were unlocked and the keys may have been in there, and that, they get in there and they put the visors down so they can't be seen, and that's kind of.
Yeah, just on that point, I don't believe the video shows anything suspect whatsoever. Again, not brought up below because my colleagues know that there isn't anything suspect about the vehicle being stolen, because that's exactly.
Both are stolen, both same time.
It's not enough. I don't think it's enough under Countrywide. It's not enough under Epstein, and that accusation now for the first time on appeal with any basis whatsoever is frankly not okay. It doesn't create an issue of fact, and it shouldn't have been brought up. And it wasn't brought up in the court below by the officer and the town of Cheektowaga.
This isn't the case. This is the case that Epstein was talking about.
Exactly, not whatsoever. And Epstein, again, just that's even a higher standard that they had, because it is a car dealership and you are dealing with cars. And even at that higher standard, they said that's not enough. Here we have a layperson that simply parks their car in the driveway.
Right.
That is not.
The legislature wanted to put that in the statute, they could.
Exactly.
And they didn't.
And they did not.
Someone would be asking us to reinterpret what a private road is as a driveway.
Correct.
There's no case law that says that.
No.
What kind of car was it? I couldn't find what.
It was a Jeep, a Grand Jeep Cherokee. Yeah.
What year?
The exact year, it was somewhat newer.
Is the allegation the keys were in the ignition?
No, the keys were not.
That was a different, okay.
Yes, that was the Calhoun case, and actually.
Right, because we're.
Yes.
Well, key fobs people use, they don't use keys anymore.
Exactly. Yeah. So a couple years ago, the Calhoun case was before this court, and there the keys were actually in the ignition and the vehicle was stolen. This court said, again, on a pre-discovery motion, that is granted. There is no legally cognizable claim against the owners of the vehicle. And so finally then, which Your Honor already touched on it, the last argument that was brought up on appeal was the Hail Mary to change the law. Again, I believe that is being argued because the law does support dismissal of the claims against my clients. Our response to that is discussed in length in our brief. I will rely on that unless the court has any other questions, since it appears you have my argument.
Senator, thank you.
Thank you.
Good morning, Your Honors. May it please the court, Edmar Kerrigan for the plaintiffs. Your Honors, the starting point is a standard of review and it's abuse of discretion, because the court below denied the motion without prejudice to allowing depositions to occur. So that was not an abuse of discretion. The second point is the premise, and the court's obviously fully aware of it. There is no conclusive bar that just because you're on private property, you could never have liability if the car is stolen. Epstein is the classic example. The language from Epstein that applies is, if this case presented a set of facts, then an exception might apply. Well, how do we ever know if a case is going to present a set of facts if we don't have some discovery? So that's correct. What the court below did was correct to say we need to have some depositions here. How can we know if an exception is going to apply? We need the depositions. Epstein was an easy case. The car in that case was in a locked garage. The keys were in a separate office. That wasn't an easy case, but even so, Justice Niehoff, in a signed opinion, which the Court of Appeals adopted for his rationale, making it the Court of Appeals rationale, the court said there that even though these cases are easy, there may be a case where an exception applies. And the court threw out on its own the possible case of a virtual invitation.
How do you balance with Calhoun then?
Yeah.
I mean, so any difference here?
Yes, major difference, Your Honor. So in Calhoun, number one, the facts were unambiguous and they were undisputed. It was simply the car's parked in the driveway. She runs into her house for a minute to get her purse and comes out. That's not an invitation to steal my car. And it's undisputed.
That's
They
not an
need
invitation,
discovery.
it's running, it's cars there, this is available. Now I know that, now I know is like, I can jump in here and take this.
Well, there's no premeditation like there may be here. We need discovery.
Isn't that kind of speculative then, is premeditation? I mean, are you arguing some sort of a collusion then between Prim and Herbst then?
I don't know that, and that's not what I'm inclined to believe, but
There
somehow,
was nothing, I mean, the town did an investigation, correct? They might have been obviously looking at these circumstances, hey, you know, the Herbst, you know, both the parents and the daughter's cars were stolen, same opportunity, keys were in both cars. I mean,
virtual invitation is not collusion, Your Honor. It's a set of facts where somehow these perpetrators know. They pull up, they stop at this prescribed destination. They go for 2 cars from the same family, 2 Jeeps, adjoining houses.
I think you see a
They
lot of
know.
that lately, you know, as far as any neighborhood, you know, there's so many cameras now and you look at either the Ring or the Blink. There's notifications to all their neighbors, be on the watch out. You know, here's a video of these individuals breaking in and looking, you know, just checking cars to see if they're open.
But
I mean,
that's
how's any different here? I mean,
It is
traders go up,
different.
okay.
When I watch the video, Your Honor, it's not what I see. I see they approach the car like they know it's unlocked. They get in each side of the car. They get in, they're gone from both driveways in less than 30
But
seconds.
if we do what you're asking, aren't we essentially changing the statute? Because aren't we basically adding driveway?
So-
and the legislature specifically doesn't have it in there. And I would imagine, unfortunately, that a lot of people leave their keys in their driveways in the cars. I mean,
So 2 parts to that. So there's the Epstein point, and then there's, do we need the law to evolve point? On the Epstein point, that's existing under the law. If there's a virtual invitation, if there's a set of facts, which again, we need discovery here. If there's a set of facts, then an exception applies. And the statute, we're not asking for liability under the statute. We're asking for liability under an Epstein exception. So that's number 1. Number 2, if the court says, well, and I would ask that we should have discovery to find out if Epstein applies. But if the court doesn't go there, then we get to your point, Your Honor. And that is whether New York's common law should evolve. And that's an important point. It's very similar to what just happened in the dog bite scenario. For years, there were exceptions in a rule. And the
we
court
have
of
versed on that.
Well, I'm so sorry, but you followed the existing law. So
That's that example.
what's really important about Flanders.
So aren't we following existing law here?
Well, I think that the existing law, number 1, is that you need discovery to find out if there's a virtual invitation. The Court of Appeals affirmed in Epstein where it says we need to have a set of facts. So we need to have discovery here, which is all the court below held, and that should be affirmed. But if this court gets to the common law point and whether it should evolve, I would ask the court to do here what Justice Acosta did in Scavetta. That was a dog bite case after Baird. The first department, Justice Acosta wrote a very thorough opinion saying, this is not workable. We need this law to change. I know you just decided Baird, but Judge Fahey was correct. You need to please reconsider this Court of Appeals in the dog bite scenario, where the common law rule was ultimately adopted. Justice Acosta did it in Scavetta, and the Court of Appeals relied on that. That was a portion of its basis for its decision in Flanders. So if this court is not going to allow discovery, which I think is the right next step, then I would ask the court to do what Justice Acosta did. I also submit, Your Honors, that if this case has to go to the Court of Appeals, or if some other case has to go to the Court of Appeals, it should go up on a full record. The court should know all the facts here, which is another reason why the best next step is to allow discovery and to affirm what happened below.
Thank you. Thank you.
Morning, Your Honors. Billy Hartford here for non-party Town of Cheektowaga. We're just here simply to rely on Mr. Markarian's submission. So if there are no further questions, the rest of my time.
Good, thank you.
Thank you.
Have a good day. Next matter is 950. Kenneth Zatko.
Gotta go.
Zadago.
Good
Caroline
morning. Good
Zadago. Must have known walking up that I couldn't pronounce a lot of words. Last name. Thank you. We're waiting for Miss Latempio. She is.
My client is here with me.
Thank you. Thank you, Your Honors.
Good morning, Miss Latempio. Thank you for being here today.
Thank you, Your Honor.
Shall I wait for?
Right ahead.
Go right ahead. To begin with, my client Ken Zadigo is with me here today. I'm Julia Leister. I represent Mr. Zadigo. He did drive, so if I don't do well, I'll be walking back to Erie County in these heels, and I could barely make it from the parking lot. So I also want to acknowledge that my opposing counsel's buried her father yesterday.
Aware of that, yes.
Yeah, so I do extend my condolences again. She's an exceptional advocate. I know that her father was an exceptional attorney and that her advocacy will be in part in his honor. And
He was well respected in any circles.
Yes, so I wanted to acknowledge that, not, our personal lives and professional lives overlap, and I appreciate it. So may it please the court. This is really a very simple case that error was compounded when the trial court simply lifted the former wife's statement of proposed disposition and made it its decision. I think that the decision is not supported by any fair interpretation of the evidence. And if we begin at the beginning, my client really does not want any part of this to get returned to the trial court for a number of reasons. The cost has been exorbitant. This has been going on since 2019. This court can make all of the decisions. If we begin with the real property, it's clear that Bemis Point was acquired by my client post-commencement. Date of commencement was February 19th. The date of closing was April 22nd of 2019.
Didn't they sign the contract though 6 days before commencement?
He didn't. He signed did sign a contract. However, he didn't acquire the house.
Right. I mean, but you signed a contract and apparently there's a $2,000 deposit placed upon that as well.
So the wife may be entitled to a portion of the $2,000 deposit, but he did not acquire.
But didn't he use the funds arguably, he didn't withdraw maybe before the commencement between $75,000 and $91,000, which he'd utilized to purchase this property?
No, the parties separated their accounts in order to survive to get the divorce. The house was purchased with loans.
Wasn't the funds taken from a joint account and placed into your
separate accounts?
Right. I mean, but at the time it was in a joint account, it was a marital asset, right?
And the accounts were divided by the couple in agreement.
But there was withdrawals made before the commencement. So it's still marital.
Let's follow that logic. The argument that there's some commingling or that the funds that were a deposit somehow were, that the client had post-commencement, say somehow were transmuted and were marital. The argument was that the military pay was going into a separate account.
How about Bemis Point?
Bemis Point. But the house was purchased with loans after commencement. The analysis of where the money comes from does not apply to whether it's separate or.
So your argument is it's a factor because it was closed after, therefore it's separate.
Well, the term is acquired. When was it acquired? It was acquired when he closed on it. Now, the use of certain marital funds, the former wife may have a special interest in that property, but she didn't make that argument and she didn't appeal the court's decision, so she doesn't get to come back. She doesn't get to come back because the issue is, the argument was the military pay, that the mortgage was paid with the military pay, so that all, the separate bank account became transmuted. That's not true because the military pay, or it's not factually accurate. The military pays a definitive amount from a definitive source. So there's no transmutation of his separate account. It's identifiable. The wife also received her portion of the military pay during the pendency of the marriage. And that's at the record at 389. This use of the military pay as one, transmuting Beams Point separate property into marital property. Two, he's having to pay it in contrary to Tedesco twice, is having my client pay this 3 times. Under Tedesco, if we, do you have more questions about, I want to make sure I cover the separate property issue because it's very important.
You think you've made your argument regarding Bemis Point?
Okay, so again, she may be entitled to a portion of it because as I said, the mortgages were separate mortgages obtained after commencement and also mortgages and loans obtained by my client's separate business, which wasn't even discussed in the case. So the financing, there's a good amount of money that was separate property that paid for this house. Now, if it is marital, the court did not take out all of the debt associated with the house. If you take out all of the debt associated with the house, the value of the house is about $10,000 because the court only took out the mortgage. The court didn't take out all the renovation loans that were part of this property. It didn't identify them or separate them as my client's separate property. It really didn't even identify the Bemis Point house as marital or separate. It just quote gave it to my client. But obviously under the statute, it's clearly separate property. She may be entitled to a portion of it. She didn't make that argument and she did not appeal the decision. Moving from there, if we come to the IRAs, words matter, and the use of the term equalization, equitable and equal were all used differently. There was an agreement to divide them, I guess, equally, but the term was equalized. I think the court really intended for an equal distribution, but what ended up happening was the wife received over between 75 and 80% of the marital assets because of a lot of these miscalculations. So, so we divide the IRAs equally. The problem came with the 72 Ts. The 72 Ts are marital, should be divided. However, my client received a $50,000 COVID payment. It was separate property. It was not marital. Post commencement, it did not impact the value of the IRAs from the date of commencement. So they added in his separate property in the calculation. What husband would really owe instead of 57 would be the 20,000. Could we take out that 50,000, which is a separate, not marital. The court decided that there would be no future maintenance. Wife did not appeal that.
You're claiming there was an error in adjustment every 10 for the next 10 years. Is that right?
In requiring, for a number of reasons, one, the court's decision said that my client's security clearance was a marital asset. My client did not have his security clearance at the date of commencement. It was gone as of January 2014. That's in the record at 245, 423, and 422. The record also supported the fact that his income was not dependent upon that security clearance, contrary to the court's decision, and that's in the record at 423 to 424. So there's no support in the record for this security clearance and increase. If the court determined that there was no future maintenance, there's no future maintenance. There should be no future maintenance.
I can understand your argument.
And then as to the court's hold back and forth on the retroactive payment of military pay and the credit for the mortgage. My client paid. The testimony is that he paid everything. And he specifically testified that he did pay the military retirement pay in the record. I already said it, 389. He paid far in excess of when 18 months or 14 months later, when former wife finally moved for interim relief, she actually got less. I mean, he was paying more than the 1,700. So wife would actually owe husband a credit of 37,000, about 37,450 for not compensating him for everything that he was paying. It wasn't just the mortgage. The record supports that he paid the car insurance, paid her income taxes, paid the son's car insurance, paid the bills in the house, paid the property taxes, paid everything.
With
Yes,
respect
Your
to
Honor.
income taxes, what's the basis for the court to give the husband a credit for the 2019 income taxes that he paid?
I think they filed jointly in that year, and so it was a joint tax liability that he paid her tax liability. My client's spreadsheet at Exhibit 26, which I think is in the record at 305, also supports, it identifies the assets, it identifies the division. It wasn't referenced. It was admitted as an exhibit without objection. It wasn't examined on cross-examination. It's a good resource for the court to look at. And I think that there should be no retroactive military pay. It was already paid. And if not, under Tedesco said that it reversed on that specific issue. It agreed with that the Supreme Court erred in awarding plaintiff her share of defendant's military. It refers to pension. I know I made a big deal about the difference between pension and military pay because I think words matter. From the date of commencement until the date of the referee's report, because it impermissibly double counted the income from the defendant's military pension because the court previously had considered that income in ordering defendant by way of temporary orders to maintain the marital residence for the benefit of the plaintiff and to provide plaintiff with funds for household expenses and fuel expenses for her vehicle. I think that applies even prior to my client being ordered to pay temporary, because he was paying. So it's all money. And so naming that money different things doesn't mean that my client has to pay it 3 times. So unless you have any questions, I greatly appreciate the opportunity to appear before you and to answer your questions, Your Honor.
Any further questions? Doesn't appear to be any. Thank you very much.
Thank you very much.
Ms. LaTempio, whenever you're ready.
Yes, Your Honor. First, I'd like to thank opposing counsel for those lovely remarks and for the court's lovely remarks about my father.
Counsel,
And
one second. Can you stay up here?
Oh, sorry. Terry,
No.
LaTempio.
No, she, okay.
Is it okay? Can you
Okay,
hear
yeah,
me?
thank you. Yes, we can.
Okay.
Thank you.
So I'd like to thank opposing counsel for those lovely words and very generous words, and for the court's words about my father. But for those of you who know my father, he would have told me get to work. So,
Yes, we do.
so Your Honors, may it please the court, Terry Lynn LaTempio appearing for the defendant respondent. Your Honors, this was an extraordinarily difficult case, and it was rather exhausting. There were multiple counsel involved for the plaintiff appellant involved, which sort of continually evaded the ability for us to resolve this case. I would proffer to the court, as I've stated before, that the facts set out in this case are rather unique due to the nature of course, these parties' incomes, which was derived from the pay status of a military pension, which is of course a marital asset, together with the distributions from their marital IRAs. Now, I would first say to the court that the trial court, as this court is aware, the trial court is vested with broad discretion in how they fashion an equitable award. There was a number of complicating factors for this court to consider. And I disagree with appellant's position that the court just simply took my post-trial submission and fashioned it into a decision. That is not accurate. I think the court looked at the factors, gave credit where credit was due. I would point out one fact that was mentioned, that my client received her payment from the portion of from from the husband's military pension. That is not accurate. She did not receive any payments. Well, indeed, yes, he did continue to pay the mortgage, the military mortgage on the marital residence. I would submit to this court that it is well-established law that both parties have an affirmative obligation to continue to support and provide the marital residence. Mr. Zadico, what he did was he continued to pay that mortgage, but the court accordingly gave him credit against those retroactive payments for half of the payment of that mortgage. So he received credit for supporting the house, and then the court used the date of trial mortgage balance as opposed to the date of commencement, thereby giving him credit for that equity that he had also contributed to, and giving my client credit for half of the payment that he had made. Your Honor, I would submit that a number of these, the primary differential in our arguments is the basis which the court, which Judge Montour directly questioned, is the Bemis Point residence, and how do you fashion that? This court clearly, the trial court clearly determined that to be a marital asset. Now, as the court noted, Mr. Zadico purchased that. He actually signed a contract prior to he commencing the action. Mr. Zadico was extremely familiar with how the law of equitable distribution with the statute of DRL 236 operated and what the language was. And he intentionally filed a divorce action prior to the just before the commencement but just before the purchase of that argument. So he intentionally could argue it is a post-commencement purchase or acquisition. That is belied by the fact that all the money, and it is not disputed, and as the court can see, and as Judge Montour pointed out, was marital funds for which he purchased that house. When you purchase a house with marital funds or any asset post-commencement, it has to be considered as a marital asset. And if you want it considered as a separate property asset, it is your burden to demonstrate what portion of that asset is separate. Now, I would tell this court that it was impossible for Mr. Mattingly on behalf of Mr. Zadico to demonstrate that, because everything, as Mr. Zadico testified, went into a single account in his name. Everything. All the distributions from the 72T, all the maintenance, or excuse me, all the military retirement pay, everything went into a single account, rendering him, in essence, completely unable to set forth what was separate and what was not. Because when you're using, now I agree this is a unique set of facts, because most commonly parties are not in pay status when they're in this situation of a military or any pension. But in this case, they are. So I think in the court's rendition of this decision, as I would submit to this court, there is a significant difference between the reduction of a principal balance of a mortgage and the receipt and the payment of the actual monthly mortgage. There is a significant foundational difference. And I think the court accounted for this sort of unfair distribution of assets during the pendency of the action in the court's decision, in them fashioning in the way that Judge Nugent Penapinto fashioned an award, because she recognized that in essence, my client was dispossessed of those funds throughout the pendency of this action. Mr. Zadico controlled all of these funds, all of which were marital assets. With regard to the Bemis Point house, Your Honor, it has always been my contention that when you pay for something with marital funds, it constitutes a marital asset. And if this court were to countenance that, I would then be advising all of my clients to do what Mr. Zadico did and create this situation which directly defeats the intent of the equitable distribution law. So not just me, but all my cohorts would be doing the same thing, because that would effectively evade the intent and the meaning of equitable distribution. With regard to the maintenance, I do agree the court at the time determined there was no maintenance, but I don't think that the court indicated that was a forever premise. In subsequent, I would advise the court that in subsequent post-commencement actions, the court has referred to this as an issue. But I understand that my client did not appeal this because this was extremely extensive, and she was satisfied with the court's decision, which is atypical, I would agree. And this court is afforded the ability to refashion that or to remand it as it so desires. But the truth of the matter is that this emphasis on the security clearance, I think, is a non-issue. I think it's a distraction because the court didn't value it. But I think what was evidenced at trial was that Mr. Zydeco is a rarely uniquely situated individual. He is a military trained cybersecurity expert who did, in fact, go to foreign countries. He provided them with assistance in establishing their blockchain and their cybersecurity defenses. He made excessive amounts of money doing that. He also continued to make money. I mean, if you look at his Social Security earnings, after he left the service, his income dramatically increased, right? Because of the use of his assets that were acquired completely during the marriage.
Ms. LaTempio, what about the directive from the court with respect to, for the next 10 years, that they determine whether or not his security clearance should be something considered in maintenance?
Well, I think that the court indicated for them to continue to exchange tax returns, which I frankly do see as a problematic issue every year. But with regard to the security clearance, I think there was testimony about that. Mr. Zydeco himself said that anytime I can get a job, the employer, whoever offers me the job, can apply for my security clearance. And he is, in essence, situated above others because of his past history and his past military experience. He indicated at trial that he's able to get a security clearance based upon the application of any consultant he provides for any job. He testified, in fact, that he had a job lined up, which was going to be a part-time job, and it was going to pay him $250,000 a year for 20 hours of work. I think his rate was $250 an hour, more than some lawyers.
Counsel, can't your client just apply for a modification each year as opposed to them recalculating for 10 years? Don't they legally have the right to just apply for modification?
Well, I think that because it's maintenance, the judge would have to set forth that ability, which I think the judge did. I don't see my client as having it, unlike child support, where she would have the ability to modify each, a number of years, every 3 years, or change in 15% of the income. I think the court provided for that, given the uncertainty of Mr. Zydeco's future. He certainly testified to what he intended to be a very financially lucrative future, and had those plans in his pocket. I thought that the court, by doing so, I agree with the court that I am hesitant to tell you I thought that was a great idea, because I see only future litigation coming from that every single year. And I agree with that. But I do think that that was the court's way of sort of allowing Mr. Zydeco to see how his career evolved, and to see if these financially lucrative contracts, which he anticipated on having, were going to pan out. So,
Ms. LaTempio, wouldn't Mr. Zydeco be entitled to a credit on the payment of the joint tax return?
Well, no, Your Honor, because he paid for that from joint assets. What my opposing counsel failed to indicate was that his payment of that came from the E-Trade account, which he had fashioned to her. So in other words, the confusion in this entire case starts when Mr. Zadico, as the court noted, started siphoning money to himself prior to the filing of an action. Not in half, but bit by bit by bit, leaving my client unsuspecting when most of the money was gone. So what he did was he paid that tax account, that tax liability, which I would note, he is the only individual who's self-employed. My client had withholdings from her taxes. The taxes that were due were his employment, his self-employment, and he did pay that from a joint asset. So I think it is disingenuous for the appellant to claim that my client didn't pay that. In fact, she did, because once again, he paid for it from marital assets. And he paid for it shortly after he commenced the action. So, Your Honor, I think also the one thing I'd like to correct is the $50,000 withdrawal that Mr. Zadico took was unbeknownst to myself, and it was never conveyed through counsel. That was a withdrawal from an IRA, a marital IRA. That, of course, constitutes a violation of the automatic orders. So to claim that this is separate property, I fail to understand that argument. Because if you withdraw money from a marital IRA after the commencement of an action, first of all, it's a violation of the status quo order, but it's also recoupable because you dissipated a marital asset. And the court, in the court's decision of going through the IRA distributions, does in fact recount that $50,000 withdrawal, giving my client a credit for $25,000 of that money, which was not separate property. That's just not correct. With regard to the other issues, Your Honor, I think the maintenance is a difficult issue. I would concur with my with the appellant. It is a difficult issue, and I would agree that it will. My concern is it will create litigation for the next 10 years. But with regard to the differential of the nomenclature between equalization or equally dividing the marital IRAs, I find this to be also inconsequential. They are the same thing. What Mr. Mattingly and I specifically stipulated to was that we would equalize the IRAs prospectively, right? And then the court would determine the retroactive issues during the pendency of the issue. So Mr. Mattingly and I specifically stipulated that 48% of Mr., which is the Majoska share of his pension, would be my client's property prospectively. And prospectively, we would equalize the matrimonial, the marital IRAs, including all the distributions, which were prospective from the date of trial. That was the stipulation. Now, whether you equally divide each of them or you equalize them, it results in the same number, right? You either give either party half or you take the differential between the distributions and you transfer that, and that's only one transfer.
I think we understand that.
Thank you, Your Honor. So, Your Honor, I do think that the court took great steps to try to avoid double counting. I realize this is a complicated set of facts. It was a very complicated matter, but I think the court endeavored and did an excellent job in sort of trying to avoid double counting, but fashioning an equitable argument, an equitable distribution, Your Honor. And if the court has anything further, I'm happy to answer.
Thank you, Ms. Otempia.
Thank you, Your Honor. I appreciate it.
For a reply.
No replies.
Thank you.
Thank you.
Thank you.
No problem. Have a good day.
Thank you.
$951 Aruda versus New York Central Mutual. Norm?
Good afternoon, Your Honors. May it please the court. My name is Scott Storm of Hurwitz and Fine, and I represent the appellant in New York Central. We all know that homeowners policies don't cover everything. They're not maintenance agreements. There are exclusions, and the exclusions in this case are directly applicable to the facts. And the facts, as we know them, are the facts presented by the plaintiffs and their engineer, their expert, Mr. O'Neill. New York Central has not disputed the facts. Mr. O'Neill's opinion places the cause of the loss squarely within the exclusions. He refers to events being caused by a backup of a floor drain, and that this is also contributed to by erosion of the soil, causing a pipe to settle, and further causing the backup. And this
wasn't that pipe though off the residential premises?
No, that was on. There's photos of it. It's directly connected to the house. And so, and I'll get to that because they try to muddy the waters. But what the expert says directly implicates or causes to be applicable the exclusion for the water exclusion for backup of overflows from the sewer, drain, or sump. And we have case law directly on the point from this court, the Lattimore Road Surgical Center case, and also the earth movement exclusion is also applicable because at least earth movement was at least somehow contributing towards the cause of the damage based on what Mr. O'Neill tells us. So yeah, the plaintiffs then say, well, maybe there's further contributing things going on here, maybe something off the residence premises, but they never tell us what that is. But it doesn't matter because these exclusions are preceded by anti-concurrent causation language. And that language says that the loss is excluded regardless of any other cause or event contributing concurrently or in any sequence to the loss. It frees the court from having to make a dominant, efficient, proximate cause loss analysis. And there's also, with regard to the earth movement exclusion, there's another case on point from this court, Kula versus State Farm. So there is no coverage, it's excluded, except there is an endorsing language that affords additional protection of $10,000 for backup of sewers and drains, and New York Central had paid that. The plaintiffs have failed to refute these coverage issues. Their predominant argument is that discovery has not been completed. More discovery is necessary.
Wouldn't the insurance claim, your claim report, wouldn't it support some of the contentions from the plaintiffs here?
I'm sorry, Your Honor, what?
As far as your claim file.
Yeah.
Could there be something in there that would benefit the homeowner here, determining that the position taken by the insurance company was from the very beginning, these people are, they use a different word.
Yeah, no, there is nothing there. And again, what's the purpose of this?
But you denied the claim before the investigation, didn't you?
I'm sorry?
Didn't you deny the claim before wasn't the claim denied before there was an investigation conducted?
It was denied based upon the facts presented by the plaintiffs. And so what's the purpose of discovery is to determine the facts. Well, we've accepted the facts as the plaintiffs have presented them and said, okay, we'll take your facts, we'll take your expert report and apply that to the policy. And I'm sorry, there's no coverage. And this court has recognized that in the Kula versus.
Well, Justice Ogden said, I don't think their expert report was available at that time when you denied, when the insurance company, not you personally, but when the insurance company denied the claim.
No, New York Central had looked at it. They had made revised or revisited their decision on a few occasions, always taking into consideration what the plaintiffs had provided, and they did provide that expert report, and that was taken into consideration. And in the Kula case, this court accepted the plaintiff's version of the facts for purposes of summary judgment, and recognized that the sole issue is legal interpretation of the contract in the light of the facts that have been essentially agreed upon.
Right. Can we timeline a little bit, because it sounds like there's a little confusion here. Okay, so what originally you declined the claim, correct?
Yes.
New York Central. But you paid the 10,000, right? What was the
Yeah.
10,000 paid before the report came out or after the report came out?
I would have to check. I'm not
Okay.
precise with
But
it.
then the report came out, was that, but that was before the summary judgment motion.
Yes,
Correct.
yes, correct.
Right, what your point is, they continued to review the file, but then they denied even after the engineer's report, correct?
Correct.
But, so all this was in the record for the summary judgment motion?
Yes, Your Honor. Yeah. Yeah, they provided a notice of loss. New York Central began to look into it, recognize it's not covered. They retain legal counsel and they provide the expert report. New York Central looks at it, realizes, continues to in its position that it's not covered. The expert then provided a second report, and New York Central revisited it again and said, we're sorry, it's just not covered. It's a backup of a sewer or drain. There's limited coverage of $10,000, and that was paid. So it was interpreted liberally in their favor.
So basically, it's your argument that these exclusions were unambiguous, and based upon that, you were right in denying the claims and
Exactly. Yes, Your Honor.
are seeking summary judgment.
Can I ask you to talk about the general business law? Because they're gonna argue that when they get up and you can't rebut here.
Sure.
So, maybe you can discuss why.
Yeah.
It doesn't.
So first of all, I think the general business law 349 argument is moot once the determination is made that New York Central made a correct coverage decision. But nevertheless, case law is clear. It doesn't apply to private contractual disputes. And these issues involve personal dealings between the plaintiffs and New York Central and their property and their individual claim. They haven't pled any facts that New York Central's conduct has broad impact on consumers at large. They fail to identify any representation or omission likely to mislead a consumer acting reasonably under the circumstances. And this court, again, has addressed similar situations in Labello, Shunk, JD&K Associates that I've referred to in our papers.
So isn't the anti-concurrent language boilerplate? Isn't it in all of the contracts?
No, it's not. It's not in every insurance company's policy,
New York Central
and it's not, and it doesn't precede all exclusions, but it does precede the exclusions in this policy in this case. And the anti-concurrent causation language has been accepted by courts broadly as being clear, unambiguous, and applicable to preclude coverage in such situations.
But it is a boilerplate language, is that correct?
Well,
it's not unique to this particular.
It's not unique to
the specific language, I would say, yes, is specific to this type of policy because other insurance companies,
but not these, not this particular property. This language wasn't drafted.
Oh, no, not for this particular property. Yeah, it's in the homeowner's policy.
It's a standard.
This is
standard homeowner, right?
Right. Yeah.
And the standard homeowner policies relate to, they are consumer oriented types of policies. They're directed for all consumers. Good.
I wouldn't deny that part of it. No.
But your point is there has to be more than just the fact that they're aimed at consumers to bring in general business law 349.
Correct. And in this case, it's just the only thing they've alleged is with respect to their particular claim. The language and the facts don't apply to other specific claims. The third cause of action for breach of the implied covenant of good faith and fair dealing. That's also moot once a determination is made that the coverage was appropriately decided. It's duplicative of the breach of contract cause of action, fails to state a claim for consequential damages, fails to allege any specific consequential damages, They've not particularized any actual losses supporting special damages, and they've not pled any provision in the policy substantiating any special damages would be available in the event of a breach. Last point I will make is that they've tried to rely upon an exception to exclusionary language. It's 2D of the Section 1 perils insured against. And they've carved that out, tried to rely upon that and say, aha, here's an exception. But that's only an exception for those exclusions. And those exclusions aren't being considered in this case. And in my papers, I've provided 4 or 5 different reasons why that language is not applicable. First of all, it starts out by saying, unless the loss is otherwise excluded, and it is otherwise excluded by the earth movement exclusion and the water exclusion. It also, there's an exception to the exception that it carves out the exclusion for water that backs up through sewers or drains and indicates that it's not applicable to that. So unless your honors have further questions, I'll rest on the remainder of my papers.
No, I think we're good.
Okay.
Thank you.
Thank you.
If it pleases the court, Joe Camardo, represent the respondent and the original plaintiff. We've got to back this up because I think your honors kind of hit on a point. What the underlying court found to begin with was the unfairness in the situation. If they thought this was so clear, the policy terms and conditions, they would move for summary judgment right away, but they didn't do that. Okay, we had cross-competing documents out for discovery. We answered all their discovery, took a lot of time and effort. And the minute that turned to our discovery, what they do, they filed a motion for summary judgment, blocked all discovery. Couldn't get the insurance files, couldn't get anything. The court also saw the fact that they can bring their summary judgment motion again. It's not denied. Just do your discovery, get it out of the way and bring it again. If you have to bring it again, at least we'll have all facts before us at that point in time. Now, they claim that there was a complete investigation. That's not true. We've got the affidavit of Mr. Aruda, the plaintiff, at 141. He claims that after the original denial of his insurance claim, he conducted his own investigation. He hired some contractors, placed cameras down the line. Okay. Then his yard was dug up. And then he invited the insurance company to come in and look at the dug up yard. Okay. Because he felt, and he also hired an expert, and the expert concluded that he believed there was a city water backup. You've got the main line going up and down the street. Then you got this lateral coming off the main line. He feels that the city had a backup, sewer backup, which caused pressure on this lateral line, and the joints broke. Okay, and that's what caused the backup. Now there were several discharges. So we're not talking about one discharge or two. There were several discharges here. So what goes to what? That's why we need to complete our discovery to find that out more. There's issues of fact here.
Their position, counselor, is that even assuming that that's the explanation for the loss, it's still excluded under the policy.
Well, there's an exception, Your Honor. And when you have competing terms in a contract that we can't agree to, or there's a difference in opinion on them, even according to our expert, then that's grounds for further discovery. The exception says, unless the loss is otherwise excluded, we cover loss of property covered under coverage A, B, or C, resulting from an accidental discharge. We have an accidental discharge or overflow of water from within a storm drain or water, steam, or sewer pipe off the residential premises.
Is that 2D?
Yes, off the residential premises. So we feel this lateral is off the residential premise because it's not on the grounds or the house, right? And you've also got the lateral line out in the street that's off the residential premises. It's very clear.
That the city line backed up? Is there any proof
That's
on
what my expert felt. The city line backed up.
Well, he doesn't have any proof of that. He didn't inspect the city line, did he?
Well, that's why more investigation had to be done. That's why we're looking at their file. He reported that to the insurance company. I mean, it's a matter before them.
Wasn't he doing this? You said earlier, he was hired by the homeowner to do some of this work. He did it before the summary judgment motion below.
No, he was just hired to look at why, okay, we've got this discharge into the house.
So he only went to a certain level, you're saying?
Correct. Correct.
Well, why didn't he go further?
Well, his job at the time was to opine on what he felt was causing this alleged backup into the house.
No, I know, but if you're relying on an exception that you need to prove, at some point you need to prove it, right? I mean, you say you can ask for more discovery, maybe you get it, maybe you don't, but you're gonna have to prove it at some point. So you're gonna need that report from him to prevail.
Well, Your Honor, I think he did prove it. And here's the interesting thing. They keep saying that it's caused by earth movement. I think what Mr. O'Neill was trying to say in his report is that you had a discharge, you had a break in the line that leaked, okay? And the proof is, okay, it sunk. That it's not that the sinking caused the original discharge, it's the dislocation of the pipes. And I think that's his proof of it. But then again, we invited the insurance company out to take a look. And what did they say? Nothing. Wouldn't even come out to take a look at it. I mean, so that gets into our issue on the general business law 349 that it's bad faith negotiations. Okay, they didn't look. The original claims adjuster to come out and said, you know what? He didn't even look at anything. It goes, there's $10,000 provision in a policy. You guys are, I'm not going to use the words here, but you guys are screwed, is what he said. Didn't even look at anything and then left. So, you know, we feel under that sort of situation without any investigation by the insurance company, that this is happening across the board, they're not doing a proper investigation, that we fit in with the confines of general business law 349. The anti-concurrent language, okay, doesn't mean what they say it means. It basically means that if it's caused solely by water seepage or solely by earth movement. In this case, we've got an accidental discharge of either the main line or the lateral line. So I don't think that anti-concurrent language even fits into our situation. Cause of action under the breach of the implied covenant and good faith and fair dealings. Again, we're not talking about the insurance claim itself. We're talking about the conduct and handling the claim. My client's seeking consequential damages to his basement, property, unsafe living conditions. I mean, there was raw sewage. We got a young family, there's raw sewage in the house, not once, but on a number of occasions. So we're just not talking some water down there. We're talking sewage that stunk and they had to move out of the house. So it's pretty serious. And for them not to take a situation like this and have it just a claims adjuster rebutting.
But their argument is they paid.
They paid $10,000 for what they thought fit into the water bag.
Their argument is we're only denying the excess of what the claimant's claiming, but we're paying what we're required to pay under the policy. We're not just denying them.
No, they said if there's water or earth movement or water backup per se, then they paid $10,000. But that's not the cause of the situation. We're within the exception to paragraph 2D, unless otherwise excluded. So I mean,
You're saying that applies. They're saying it doesn't.
Right. So Judge, we've got a basic difference in the facts. We've got a basic difference into what policy provisions apply here. So this is classic for a summary judgment. We should be allowed at least to see the insurance file because they didn't even hire an expert to rebut our expert.
Well, he said he agreed to your facts.
He didn't agree to the facts. What he's trying to latch onto in the expert report is that the line slipped down. Okay, you had earth movement, and therefore that caused the discharge. What my guy is saying, the pressure built up, right? That caused the line to break apart. That caused a discharge. So there's apples and oranges. And not only that, he keeps pointing to the expert report. My expert also filed an affidavit afterwards, okay? The affidavit that the court had before him saying that specifically, that I feel it was caused by city backup, which caused pressure on a sewer line gravity joints. That's what he said in his affidavit. So if anything, he clarified his position even further in his affidavit. So that's what the judge has before. So we got competing affidavits. We got one from Wheelock, the claims adjuster, right? We've got affidavits from the plaintiff, and we've also got an affidavit from the expert. So I think the matter should go ahead and we should flush this out, because if it was really true, okay, that we didn't have anything here, why don't they move for summary judgment right off the bat? But yet they deny our discovery, and they turn around and file, I think, 55-page brief and then a 27-page reply. A little excessive on something that's very, very
I
clear.
think we're aware of that. Yeah.
Okay.
Appreciate your time. We've all read those.
Thank you, Judge.
Thank you so much. Have a good day. Last case, Rizzo versus the Board of Education of East Aurora. The Miller, Ms. Deckert. Mr. Miller, good afternoon.
Good afternoon, Your Honors.
Thank you for your patience.
Thank you for your attention. It's greatly appreciated. We're here today, and I know the court is aware of this, but just to summarize briefly about a long-term Spanish teacher at the East Aurora School District who, after the district went back to a hybrid teaching model after the onset of COVID, requested a reasonable accommodation of working from home, something she had successfully done during the statewide closure, right? The problem is that the state human rights law requires an individualized assessment of every reasonable accommodation based on a disability that an employer receives. None was done here. A denial was issued 10 days after her request was made, before ever having a conversation with Ms. Rizzo, before ever looking at her specific circumstances, which were dire. As I say in my papers, and I'm going to read this because I screw it up every time, no matter how many times I say it. She was diagnosed with genetic immune deficiency resulting in severe combined immunoglobulin deficiency, which effectively requires every 2 to 3 weeks to get intravenous injections of antibodies that help her immune system keep her safe from infections. We all experience COVID. We all know what that entails.
Counselor, I don't think anybody disputes the fact that your client has this medical issue. There was a lot of back and forth here in the record. There was meetings and emails back and forth. There was a lot of conversations. I mean, the district's position here is you have to be in the building in order to perform an essential function. That's their position. If we were to agree that supervising students is an essential function, then, I mean, isn't that the first issue we've got to confront? I mean, your position is there's some question of fact on that.
Mm-hmm.
But if we were to determine there's no question of fact on that issue, that's the end of the case, isn't it?
No, Judge, I would disagree, because the district's own conduct belies its argument. They offered accommodation.
But we got to look there first, don't we? Whether
Sure.
or not it's an essential function.
Sure, I think that essential function analysis is not just something that's set in stone. It is an individualized analysis for each particular position, each particular teacher. Teachers are different. Sure, I agree. Supervision of students is important. There's no dispute about that.
Isn't that a duty? Isn't that a duty of a school?
Of a school is it may be a part of a duty of a teacher, but a teacher can also effectively deliver her teaching duties without necessarily being physically present in the classroom. And the district offered accommodations where she wasn't in the room. They offered an accommodation where she was in an adjacent classroom with an aide in the room with the students.
Weren't those offered by someone who really didn't have the authority? Weren't they always subject to superintendent on agreeing to these? I mean, they were attempts to made, but the superintendent still had the final word, and his interpretation was, no, this is not going to happen.
That is their position, but that's a factual issue, respectfully, Your Honor, for the jury to decide. As Ms. Rizzo sits there and hears these offers coming from Mr. Membretti, she doesn't know that. She's going through a discussion back and forth with Mr. Membretti about what these possibilities are.
That issue, though, she didn't accept that. Assuming that it was offered to her to, I think, teach out of the Parkland school, she didn't accept that accommodation.
Correct.
The only accommodation that she was willing to accept was to work from home.
Based on her doctor's orders, that's all she could accept.
But that's not disputed. That was the only accommodation that she would accept.
Correct. We don't dispute that.
Right.
Correct.
But and this, as I'm trying to get my head around, how could she supervise students or discipline students or provide any emergency services to students who are in the school if she's in her home?
It's a fair question, Your Honor, but I think the district's conduct, they belies what they're saying. They had arrangements and they had looked at and offered to Ms. Rizzo the opportunity to have an aide in the classroom to provide for that supervision. She didn't need to physically be in the classroom. They offered her the opportunity to teach from Parkdale Elementary School, an entirely separate building, which is the functional equivalent of working from her home. There is no difference. So I can't get my head around how they can offer that, at least in the perception of Ms. Rizzo. Again, a factual dispute that we don't think was appropriate for the trial court below to make at summary judgment when we have a record on disputed facts. And also something that she successfully did, albeit under a state mandate, from home while the shutdown had occurred. She had successfully taught her students.
I don't think anyone denies that, at that point in time, all teachers were teaching basically virtually, and
Correct.
So, I mean, the fact that she did it and she did it well as far as the teaching is concerned is a factor, but there's also, as Justice Del Conte has indicated, there's essential functions of a teacher, which are required to be in person and can't be accomplished virtually.
Well,
Can I ask you a question?
Yes.
As a Spanish teacher, was there also another teacher that was there? Did she teach the students in a room alone, or was there a homeroom teacher or another teacher?
I believe she was the only middle school Spanish teacher, but I'm not certain on that, Your Honor. But the questions are fair, but I don't think they're determinative of the question before this court, which is, did the trial court below improperly dismiss the complaint in its entirety, make credibility determinations that are really the province of a jury at trial when we have disputed issues of fact? This case is ready for trial. We filed a note of issue. We didn't get a written decision, so we made the arguments that we think are appropriate and we think the judge had considered at the time of argument of summary judgment. But if I could move on to one other issue, it's this interactive process, right? You've seized upon the fact that there were many back and forths. There's emails, there's conversations, there's meetings. The problem with it is the decision had already been made. It was made in August when the letter was received from the district that they did not have a need for any full-time remote educators. There was a policy decision that they didn't want anyone working remotely. It wasn't that they couldn't do it, that they couldn't put an aide in the classroom, that they couldn't put her even at a neutral third-party site, according to Mr. Mambretti when he sent that in an email to Mr. Russ. They could put an aide in the classroom. They just didn't want to do it because they were afraid of the precedent. And that goes against what the human rights law requires. It's not the individual assessment that the human rights law requires. And when the interactive process after a denial has already been issued, it's not done in good faith. The decision was made and they were going through the motions to placate her. They knew what the decision was and that it wasn't going to change. That's the problem here. The school did not satisfy its obligations to go through that meaningful back and forth, that meaningful consideration of what she was asking for. It was literally life or death for her. So just to touch on briefly, since I don't get a rebuttal, there's some case law in the respondent's brief, one in particular from the District of Connecticut that equates that case to this case because it deals with a Spanish teacher who was denied remote work. It's not a controlling case, respectfully. It also was under the framework of the federal ADA, which is a much more narrow statute, where the statute here at issue is the state human rights law, a far more broad, where the legislature actually dictates in the statute to the courts that it must be interpreted broadly, and that all defenses and exceptions to it must be interpreted narrowly. I don't believe that happened here, and my client should be entitled to her day in court before a jury to determine all these factual issues. So unless there are other questions from the panel, I'll rest on my brief.
Mr. Miller, thank you.
Thank you.
Ms. Deckert.
Your Honors, may it please the court. I'm Heather Deckert and I represent the respondents in this case. I had many things, that I would like to share with you about this case. But I will obviously keep my remarks brief, given that I am the last person here today. I do appreciate your attention. I want to start just by reiterating something before I get into the questions you had asked about. Julie Rizzo is a middle school Spanish teacher at this school district. She is still a middle school Spanish teacher at this school district. She made this request to work from home at the start of the 2020-2021 school year, at which time the district had just reopened its doors for students. The period of time during which she was able to teach virtually, students attended school virtually. Her job duties were obviously far different than when students are in school.
So before COVID, she could teach in person.
Before COVID, she always taught in person, and every teacher in every district understood that teaching happened in person.
There's no question that she had this same ailment at that point in time.
She did have the same ailment. The district has provided reasonable accommodations to this particular teacher for a number of years. They're not at issue in this lawsuit. They have provided her time off to obtain treatments and different things like that. All of the claims that are asserted in this lawsuit all revolve around the fact that she wasn't permitted to work from home during that school year. This is not an employee who was disciplined or terminated or lost her livelihood. This is an employee who was returned to work after that job protected leave of absence. She came back the following school year and has been working since, after the threat of COVID-19 was less threatening to her health. That's why that was an effective accommodation. It saved her job for her. It allowed her to come back to work. You had asked questions about the essential functions of the teacher's job duties and why that job duty can't be performed from home. I do want to clarify, plaintiff's counsel is correct that she was the only teacher in her classroom, right? So she has to provide all of those job duties, including the instruction, the supervision. She's the one responsible during an emergency. She's the one responsible for discipline. She's the one responsible for supervision. The Commissioner of Education of New York State has made it very clear, multiple cases, supervision of children on school premises is always a part of the duties of all members of the teaching staff. That is not a duty which can be excused. The district did make extensive offers of accommodations, which they thought about, they talked to her about, they reviewed her medical note and talked to her about her needs. That note said that she should avoid shared restrooms and groups of people, right? So what they offered were extensive in-building options, including staggered start and end times of her classroom. She could use a separate door and have a classroom near to the door, so she never went in the hallway when the kids went in the hallway. She could have access to a single person restroom. There's a distinction I want to make between this offer of her not teaching from the classroom, because I want to make sure we're clear on what was offered and what wasn't. What was offered was that she could teach from the classroom next to the classroom where the kids were in. The district called this a low contact teaching option. They would put an aide in the classroom, and an aide is someone who's paid on an hourly basis, who does many job duties throughout the building. They could just come into her classroom when the kids were there. They could pull that aide in. They wouldn't need to hire a separate long-term substitute or certified teacher to be in that classroom in the event of an emergency or for discipline and those kind of issues if they did this. The plaintiff rejected this option because it was low contact. It wasn't no contact. It was understood that she would be responsible in the event of an emergency. It was understood that she was the person responsible for discipline. It was understood that she would be next door so that the supervision and instruction were not disrupted, right? She could just open the door to the classroom and she could be there in a minute.
I think we're familiar with that.
That was offered to her, right? The other issue, the conversations that were had, this was a very extensive
I think
interactive
that Justice
process.
Latanti indicated those were all rejected, right?
They were rejected, and she can't credibly say that they were, who could offer or not, right? That is information and evidence that can only come from the district and the superintendent, because they're the ones who had the authority to make the offers. There was another question I just wanted
Were they valid offers, or had the decision already been made?
That was actually the point I had made a note here about. The district received her request in mid-August. They reviewed the request to work from home as a teacher. They reviewed the medical note, and the initial response is, no, you can't work from home. That's August 20th. The district superintendent testified that he repeatedly reconsidered and reassessed this. He he discussed these issues with his board. He allowed his assistant superintendent to try to brainstorm creative issues. This specific individual didn't go on that leave until I believe it was after October 7th, right? She remained on she was just in a paid status while they tried to figure this out. His testimony, which is cited throughout the record, is very clear that no matter how many times he reassessed this issue, no matter how many times he was pushed on this issue, he would come to the same conclusion. We kept coming back to, we can't find a solution. Your Honors, if there's no questions, I'll rest on the papers.
Thank you very much.
Thank you.
Recess.